Hey, AP Government, welcome into your weekly address. I know it's been a while since we did this thing, but we're outside. It's a beautiful day here in February, so let's get this thing started. I'm really going to do a quick whip around, and in that whip around, I'm going to cover just a couple details with regards to the Bill of Rights and how, through the incorporation of the 14th Amendment, these Bill of Rights, liberties, a couple different nuances that go into them. And what I want to just hit you up with first are a couple terms, key terms that you definitely need to know. I've got out our trusty new GIA 2.0 here, and basically, I'll kind of direct you to which pages you can find all this information, so that if you guys want to further clarify anything I say, you can just turn right to it. So I'm starting on page 99, which is what we've been covering before, and I want to get into a couple things that the Bill of Rights set out to do in the Constitution, which is to prevent the government from overstepping its powers. One is a bill of attainder, a bill of attainder. And a bill of attainder essentially protects an individual's rights that an act or anything, when I say an act, I mean something that a person does. I don't mean like an act of Congress, okay? So an act, anything a person does, a person can't be found, that act can't be found illegal without it going to trial. That's a bill of attainder. That means that, if you're arrested on the street for listening to bad country music, that can't be declared illegal unless you go to trial. And now, of course, I'm making a facetious hypothetical remark, but my point is that something can't be declared illegal unless it goes to trial. So the Constitution protects that. The other issue and this is a term that really is important, is an ex post facto law. And again, you can find this on page 99 of GIA 2.0. An ex post facto law is that an act cannot be punishable. An act cannot be punishable as a crime if it was legal at the time the act was done. So let's say, for example, I'm going to use performance-enhancing drugs because in Major League Baseball, this was a super issue that came up in the last 2 decades. So let's say a player is taking performance-enhancing drugs, and they get caught doing it. Well, there's no law against it, okay? So it can't be declared illegal if there's no law against it. But 5 years later, the federal government passes a law that says Major League Baseball players cannot take performance-enhancing drugs. That player cannot be punished retroactively. Now, in baseball, the federal government does not punish players for taking steroids. That's actually done within the game of baseball itself. The organization polices performance-enhancing drugs itself. But I use that example just to bring up a hypothetical. You cannot be punished for an act that you did legally retroactively. So no matter how many years pass, if a law comes in and a federal law bans cell phone usage, you can't go back and be retroactively arrested for using your cell phone before the law was passed. And so through bills of attainder and ex post facto laws, that protects individual rights in the Constitution, and the Bill of Rights is there to once again uphold those liberties. Now, we've hit the Bill of Rights pretty hard, especially 1 and 2, which again, don't forget tomorrow, after you guys write your FRQ, you're going to break up into groups and do your gun control debates. But as far as the other amendments, Amendment 3, which is the no quartering of soldiers, that really hasn't been put to the test much in American history. But Amendments 4, 5, and 6 really are ones that have been tested through incorporation as well as through different trials of the Supreme Court. And the beauty of these is that we actually covered most of these. Okay, so I'm just going to kind of quickly throw these out there almost as like a review for you while incorporating some other nuances that are also important. So when it comes to the Fourth Amendment, that's the search and seizure amendment. The big case is Mapp v. Ohio. That's the one that always seems to come up with the Fourth Amendment. And anything related to the Fourth Amendment here is on page 99 and 100. But one thing to clarify is there's a couple of nuances in Supreme Court cases that have actually strengthened law enforcement's roles in this case, where your Fourth Amendment rights are sort of most likely to sort of be stretched. And according to the courts, this primarily has to do with the fact that automobiles are not permanent residences. Because they are mobile, they can move, and the jurisdiction has to be sort of, for the police, has to be sort of enlarged because of the fact that cars are mobile. So in other words, cops have, and law enforcement agencies have stronger abilities to search your car and your automobile and that is protected throughout interpretations of the Fourth Amendment. Which is why a police officer does not require a search amendment to pull you over if they have a suspicion of drunk driving or any kind of driving under the influence or speeding, for example. Now, if the cop wants to search your car throughout this process, he can still get away with that, or she can still get away with that, as long as there's probable cause. And that is true basically in terms of all these Fourth Amendment issues. If a police can deem probable cause, then they do have that right to search your home, your domicile, the school, whatever the case may be, and even the car. And so reasonable suspicion or probable cause really empowers the law enforcement agencies in this case. It's important to realize, though, that this unlawful search and seizure sometimes gets brought outside of, physical search and seizure. Let's take drug testing, for example. There have been a couple Supreme Court cases and a couple Supreme Court rulings that have upheld the constitutionality of random drug testing. Now, random drug testing, certain employment agencies, certain professions require random drug testing. Sports is one. High school athletes, college athletes, professional athletes, they're subject to random drug testing. And the Supreme Court has said that that's okay. And typically the challenges to the drug testing comes under the Fourth Amendment. The court said that's okay. Same thing for teachers, for example. When I was teaching in Connecticut and I used to drive the bus at the boarding school, I was subject to random drug testing. And that was not only part of our contract, but it was upheld by the courts, that drug testing is not in a violation of search and seizure. So it's important to realize that while Mapp v. Ohio is the crucial case here when it comes to search and seizure, there's also the case that we talked about in class about frisking, and that gives the police officers the right to frisk if there is a suspicion. But remember, if they find nothing, then those cases have, then the suspect or whatever is set free. So Fourth Amendment protection is usually upheld. The courts are very strict in protecting people from unlawful search and seizures. Fifth Amendment, the big ones in the Fifth Amendment are the self-incrimination and the double jeopardy. And what's important about double jeopardy, that's the clause that says you can't be tried for the same crime twice, and self-incrimination, that protects a person from really coerced interrogation. And if there's one case that really is at the center, the fulcrum of the Fifth Amendment, it's Miranda v. Arizona, the one that happened out here involving Ernesto Miranda. And these are all on page 100 and 101. Pollack did a wonderful job on the Miranda rights, so I'm really not going to go back over that. But what I want to add about the Fourth and Fifth Amendment, a sort of a way to tie these together, is something that was in a Supreme Court case called Weeks versus United States, 1914. This laid out what the Supreme Court called the exclusionary rule. And in the exclusionary rule, this protects people from having illegal evidence used in trial. So the courts, the police can't the police can't seize evidence illegally and then use that against a suspect in a case. The evidence must be collected and follow the procedures, and that protects people's rights even greater. So that's actually a new term for you guys, which is the exclusionary rule. And that often gets tested under the Fourth and Fifth Amendment. The other big amendment is the Sixth Amendment, and when that comes down to your rights to counsel, your right to a fair trial, etc., right to meet your accuser. Zawaid covered Gideon v. Wainwright, and Gideon v. Wainwright is a really important case that exposed the fact that a man in Florida was not given the right to an attorney, and therefore he filed certiorari and was able to win that case, which is why now you hear in the Miranda rights that a lawyer will be appointed for you if you cannot afford one. So everybody gets a chance to a lawyer in trial. Now you could represent yourself, and that is possible, but that's why we have people like Brian Wilson, the Texas Law Hawk, and people that go to law school to represent in court. Now, one of the issues that's interesting about the right, your rights to counsel in the Sixth Amendment, is that it also affords you the right to a jury. But the court has had to stretch itself pretty thin, looking at jury selection. And certainly, and when we get into next week or this week, the civil rights and discriminatory practices that states upheld, despite the Bill of Rights and the civil liberties of the 14th Amendment, oftentimes jury selection is one that is contentious because when lawyers select juries, sometimes they have to use bias to weed out potential jurors. And so throughout the history of the Supreme Court, there have been challenges to whether or not it's okay for courts to use bias against jury selections. Let's take, for example, a rape case, where a man rapes a woman. Lawyers, women tend to be more sympathetic in that case, just generally speaking. So, in some cases, juries have sued. People on jury selection have sued because they felt as if they were denied the ability to serve on the cases because of the fact that they were women. And throughout most Supreme Court cases involving jury selection, this is upheld. The Equal Protection Clause of the 14th Amendment usually denies lawyers the ability to discriminate when selecting a jury. The same can be said for a case involving minorities. You can't just stack a jury with all white people in a case involving a white person versus, let's just say, a Hispanic. Okay, the 14th Amendment would protect people from that biased jury selection. So equal protection laws deny lawyers the ability to discriminate people for their race or gender or whatever other factor when it comes to jury selection. That's pretty much where we're going to sort of leave off for today. I don't want to overwhelm you with too many things. I think the terms that you need to know here are bills of attainder, ex post facto laws, exclusionary rule. Those are important. But these other concepts, and again, you can all find these in pages, basically 99 up to 106. And speaking of 106, that's where we get into the right to privacy. And we had those two cases, Griswold v. Connecticut, Roe v. Wade, about how the government has attempted to define right to privacy. And we'll probably spend some time actually talking about those on Tuesday. And then really the last topic on Chapter 4 we're going to look into is civil liberties in the face of terrorism. And how did 9/11 in 2001 change the application of the Constitution? And what happens when you have people that are brought on American soil at military bases around the world, and they, do those accused terrorists get the same civil liberties and protection to the Constitution as we do here in the United States? That's just a little tip to the spear for what we got coming this week. Make sure tomorrow on your FRQs, though, you guys are focusing on some of the recent issues we've been talking about, especially First Amendment. It's going to tell you straight up, you need to know that First Amendment quite well for the FRQ. So good luck studying. Hope you guys enjoyed this. As you know, the past shapes the future. Take care, AP Gov.